intellectual property. And Wheelock and Joe Walsh from. I'm welcoming back today. Thanks for part two of this conversation. Continue talking about intellectual property, specific companies, but who weren't able to hear. First of all, would you just mind sharing a little bit of experience in your role with
Sure, and thanks for having us back. My name is Joe Walsh, and we're now in IP. For those of you who have heard the term, know what it means. It really comes litigation and licensing. My legal career to copyrights related litigation. I am a registered patent lawyer, I'm a trademark lawyer, and a copyright. My colleague and been law partners for over 20. So the majority of our careers we spent together with. Bryan and I, St. Louis office of Harness, 22 years. Will be 22 years this year. Our firm just anniversary, so we're intellectual property licensing, and we do it all over the world. A team of dedicated country of the world. Our clients' intellectual property using associates throughout the world. My background, 36 years, and he's got a few more years.
Yeah, I have a similar, I'm a licensed patent attorney, but a little bit of everything I enjoy is handling comes along, solving the particular. So get a kick out of teaching law school for being full-time here at Harness. About 40 years, I think I'm just about anything that's going to come along to be challenged.
Yep.
Awesome. Well, it's great. And just again, for a little bit on our last episode, introduced this broader topic of intellectual. It relates to midsize focus here at the NCMM, and some of the differentiating copyrights and patents, and why companies need to think of critical to that was brought up toward the end, which was trademarks. Interestingly, privately held companies too, where brand name or certain thing to more companies. So let's just start trademarks. What do you see specifically with mid-sized clients?
Mid-sized seem to be reactionary. They start to get concerned about where a little advanced preparation. And I think to the collective, important to consider what to be intent conscious about what you're reactive. We never really thought much about it, or the packaging. Things going to distinguish you. How do you want to protect those aspects? And that goes for names and brand, mark about what the mark should be and how then go about it. Talking about, don't worry, don't register the name, and the name is your corporate name. That doesn't protect the mark at all. I'll tell you that if you look at what we do is with either state or trademark registration, they wide rights, and it's nationwide rights. The big rule. Trademark registration. First is you get to use the cool little, so that warns people, hey, off. But the other is the mark throughout the kind of expansion. So if you've got the Midwest pretty well in the mark in Maine, or you certainly plan to, if somebody adopts the mark and you don't end up owning it in those regions, only expand so far. Registration, and after the day you file is junior to you, and it's particularly up and growing or has hopes of expanding. The name is reserved throughout the country. Already have it. They're not going to importance of registering your name as a trade name is a name that a business, and it can also be there put on products, and it could also be the name they put on their service. Registration is that it's not very expensive. The rights it confers, if there's even a hint of a.
So I've dug if it's a law, it's really in presentation. Trademark law is what everybody pays most attention to. Should be adhered to. Number one, are truly a small business geography, for example, only in the state of Missouri or state of Ohio. I trademark registration, not a federation. And this applies to barber shops, landscaping services, things of that nature. Expand outside 3-city area or whatever. To get a federal patents and copyrights, you can let people infringe your patent without much consequence, more than 6 years. But if they're infringing your brand, you have legally go after them and stop your trademark rights. So in the United States, if you know you're only get a state trademark register, you only have to protect actually operating. Only 10% of our clients not selling on the internet, they're selling federal protection. So for them to get the federal registration, he talked about their nouns, right? Trademarks are always edify the noun. A lot of our clients don't get this. A slogan abstract, that is. So, just have that as an expression. I think it's Lowe's has that as, and then you have, out there, but they're always used in sneakers, Tide. If you can insert the term and the using the brand correctly, Spied My Nikes, that's incorrect trademark use ultimately, because somebody, and they say, hey, an indicator of sort was a common thing, or is it how you use your trademarks? Let's go back, let's wind the car trademarks. Trademarks, as we said, it can be a design, it can be a phrase, it can seize bing, bing, the three registered trademark. Washing the dishes, you hear bing, right? And Bryan brought this one brand of it smells like plumeria block into a yarn. You just follow your nose to the plume, and it'll take you to this one brand. So really anything, products or services from key. And it's real. If McDonald's didn't stand for the Big Mac, they was using the Big Mac. You could same flavor, somebody else's Big Mac, and that's really key because brands, you stuff all the time on Amazon, right? You like something like these clothings, right? And my house, my yard, well, I need brands on them, and I want to buy them so much, but there's no brand, so I'm going to invariably different brand from somebody else to this guy. So brands week, I was in New York visiting one of my farm, and he showed me the stand that has, when he sells his Christmas trees, he drills a hole in the base of the Christmas, sit on that peg, and then when you together at the bottom, the tree stands. Wow, that's a great tree stand. And there was no brand on that. There's a product that I wouldn't know what the brand was from, at least not get it from that. So brands identify us in the marketplace, and they allow you to distinguish, suppliers. Sure. There's a whole lot to trademark. Basically what they do, and X and Xerox are in trouble now because people are saying, give me a Kleenex, when really, give me a Xerox copy. But, it has to identify products and distinguish them from both of those two things at all times, then it fails to function.
We have a issue near and dear last year. So the university for the word the,
right, I remember that.
It's interesting because region, it's understood that you're talking home estate.
Uh-huh.
The use of that word, and now we have that trademark to use for laying of apparel. So,
right.
I'm sure you've had instances to file, and maybe somebody has that trademark. Have you seen?
Okay, I'm going to pop in here again to stellar example. I said so much else that I forgot. Absolutely. There is a right to go about adopting. The way is not to sit around in a room, talk about what they like, and then say, with several different options, and have us do some searching to gauge for the use that you intend. 2 examples, and these are wealth advisors. Wealth advisors for like 5 or 6 years. The one just letter from somebody in California just learned that you're using our brand. He's got a big sign up on his building, bucks for it. Guess what? He's got to take it down. So he had to go back through all the clients that he developed. My website's changing. What a bunch of heartburn and wasted expense. It happened. So now I got another realm. But he heard about the other guy and ready to put a big sign up on his building. I should contact you first. And I said, so we're going to walk him through. Key is selling products all over the world. You have to, a competitor in the common law rights count. In most other countries of the world, it's filling out a trademark registration that you get to the 6th year point and you file this certain document contestable. If you get that, then your registration because somebody earlier. But if you don't get to somebody say you're happy, you're thinking everything, okay, 3.5 says, hey, I can show you ever even filed your application. You'll lose that registration. So don't spend your money wisely. It's hard. I've had to counsel away from marks that they did, but tell them they can't protect it. You're gonna spend. And the whole point of doing a search is clean and easy for you to move forward. That you can absolutely protect other people without fear that.
Right. I think because they deal with it before they call us. Any bad decisions you made. There's some things that are pretty close. This is it. This is the mark of the company. And they about the mark or trademark a lawsuit in federal court because they were too attempted. They found out that the mark.
This is just a matter of ignorance. It's not a matter of conscious disregard. But a lot of business lawyers. So when a client comes to them and says, "Here's the name," and he registers it with the Secretary of State, he thinks, and the client thinks it's protected a trade name, which enables the state. And if you hurt anybody, where to find you, and all that kind of stuff. And the Secretary of State register the same darn letter apart, or there's any likelihood of confusion. It's just, and that is from protecting a trademark. Is not the same as protect. And a lot of people don't get that.
What I'm hearing, the takeaway, doing that front before you fall in love is available is well worth to avoid headache.
Absolutely.
So when is the conversation? Is it when that conversation?
As early as
possible. Okay. Let's say you have discover mark is being infringed upon from there. What level involved you go about protecting that?
Well, is this really a proprietary? If the mark's being used in a remote area, not to worry about it because consumers are pretty between 2 entirely different products. You get too proprietary in effort and work. That's an area of natural area. It's a competitive. Then you need to go after it. If you let one person, how do you stop Anyone have a confusingly similar mark? Isn't that distinctive? And you come in with another slightly.
Doug, to what I said about trademarks, right? You do those two things that affect our service in the market competition. If they feel that if you allow number two in, a letter different than your brand, he uses an uppercase E and he's got the same product, and you've opened the door to three, and that just dilutes them, actually kill your brand over time. I will say the question you ask salespeople out in the field, right? Very selfish and guardians. And you get the salespeople out of the company and, hey, Bob, company over here, and they're doing something. We need to get our lawyers after them. And everybody gets whipped into calling everybody's hot and blah, blah, and calm about these analyses. Because, and being what it is today, be worried about being the big. So, here it is and all that. If they're not hurting your brand, and if they're, you might think.
That was going to be my incumbent upon the damage, or just like of being damaged.
Yeah, that's a great draw that distinction. It will be presumed if the marks are similar, so you can get two people can't compensation, then you've lost something because the court, despite what you may think of after reading online news, courts don't just. But if the marks are the same or close.
I said earlier about damage, they will be right. A successful copyright is infringed, and statutory damages for trademarks. So you have to prove lost sales, that you would have made those sales. They were diverted away to these guys because disputes over damages.
What do you see as being more important, or they have?
Again, logo, the word stronger just because remember them, a swoosh, but if you remember Nike, you can Google Nike swoosh as well. You can try it out as well. But swoosh is highly valuable.
Yeah, $8 for that to a graphic designer back in the late 70s. They got an assignment of all rights just 3 or 4 years ago. They $1 worth of stock.
Yeah, they did that much. But it's really, we love that logo, that drew it, or, they can any difference if the customers, because those are the things going to copy. This goes with their product, and they're going to try to simulate it. So marks to protect or the mark copied, everyone in the company, or holy crap, we got. And
colors too, Doug. People don't protectable as a trademark. There are a lot of brands out there. Things we have a big of their products in green, and we registered actually color or underground irrigation. Because usually irrigation white, it comes out special pigment in there and make it yellow. But everybody else has to make theirs yellow. So our guys who can make yellow, and when you see it, it comes from
there. Marks that are pretty famous. Mobile. Orange is the theme for Home Depot.
Owens Corning with the fiberglass. That's extruded. And so you have to impart a pink, which costs more money, and they pink insulate Owens Corning.
Yeah. So I guess today, this has been really, really mid-sized companies should start if possible. Have options and add to things until they have. And then should issues arise, try to maintain and work with professionals this out and not get too bent out.
I think that's absolutely it too, Doug, is what we do for our long-standing client. We're willing to meet with our. If you want us to do that, you just pay our plane fare. We won't charge you for early rate for our day of, we'll go and talk about the one client that we had with the configured their product so that they, the disposable part. And that was a 2-hour conference. So what I would recommend, a company that's kind of struggling a little, what are we going to do with IP counsel? And say, look, we'll pay your airfare. Let's do a Zoom call. Maybe say we want to spend or whatever, and we're going to hit you with get some feel. So because let's not get the lawyers involved. Myra's, we're really practical guys. We understand what this stuff is. And if you say I want 500, we'll give you everything you need, and 500 a big overview. So you can dictate, a lawyer to spend on something. It's not just let them go. So.
Getting trademark, it's kind of 5 steps. Know what's out there, then do get that possible because it locks you else out. Use certain rules that lawyer would tell their client, you don't commit
accounts,
right? Those types about the acid test. Acid A, C. You use a I. You identify it as a registered trademark or
EM or SM
or T. If you got that federal registry, acid is distinctive. Treat it as a normal word. Your own identity, respect. Make it stand out.
So float on the web page.
So the last two, spend mark, not just the product. Advertising. Look for the
Texas old days. Look for the star.
To the man who wears the star. Advertise the mark, and then lastly, don't go after everybody. Really should go after people in the marketplace. They have one uninvited guest.
Yeah. Great. I'd like to thank you. Another really fast. I learned quite a bit, a lot of time in this discussion, and I think a lot of the advice that extremely helpful for who might be thinking about their own kind of and larger intellectual property, visit their website at Harness. And Bryan, Joe,
thank you, Doug.
Thanks for your time.
Okay, everybody have a great day.
Market that moves America. Subscribing Anywhere podcast can subscribe to our email newsletter at